That sounds like a great plan. And Lewis, take it away. The floor is yours.
Okay. Well, so quickly, you may have provided a little bit of background, but I'll just quickly self-introduce. So obviously, my name is Lewis Cohen. I'm a partner and co-founder of DLx Law, which is a law firm based in New York, Wilmington, Delaware, and Washington, D.C. We were founded about 3 years ago by three professionals seeking to sort of mix sort of traditional law and traditional experience with kind of what we saw as kind of the cutting edge of blockchain. And I like to think we were really among the first law firms to identify the digital asset space as something that really would require deep levels of expertise. And that's what we sought to bring to the table. My own background, and as Doug will recall, when I had more hair, was doing capital markets work in an international context, but much of that was doing securitization and structured finance. And in fact, of course, Professor Guseva, something you have been very interested in as well, have written a lot of great scholarship on. And I think there's a lot of connections, as I'll try as we go forward, between structured finance and the blockchain space and digital assets. And I don't believe it's a coincidence that we see many of the professionals who had experience in the area of structured finance kind of gravitate relatively more quickly into blockchain, because I think a lot of the themes and issues in blockchain resonate for folks who had a background in structured finance. So that was my own background. My introduction to blockchain itself came in late 2015 when I was doing work with the Structured Finance Industry Group, which is the trade association that represents the structured finance industry. They've since changed their name, and we'd spent quite a lot of time between give or take 2008-9 at the start of the financial crisis through to around 2015, kind of addressing regulatory issues and SEC issues among others. And by the time we got around to 2015, things were finally starting to settle down. Most of the Dodd-Frank regulatory reforms had been implemented, and we were kind of wondering, where do we go next? And I was at a board meeting. I was sitting on the board at the time and raised my hand and said, well, I think this blockchain thing is going to be big. And I guess fortuitously, the executive director of the trade association agreed with me and said, Lewis, why don't you kind of create a working group and a task force and kind of lead that effort? And that kind of took me down the proverbial rabbit hole and ultimately led to a increasing amount of client work in the space and ultimately founding our firm. So that's kind of, my own background and what I bring to the table. At this point, I think your students have a broad idea on blockchain, and I think we talked about this a little bit. Is it worth just maybe just doing the very short basics of when I use this term blockchain, what I'm sort of talking about, just to reorient everybody? So I think obviously at this point, people well understand Bitcoin. The technology underlying Bitcoin, though, is the paradigm of blockchain, but not the only way in which that technology has been used or developed. And broadly speaking, as I think most people probably understand, the fundamental core idea that whoever Satoshi Nakamoto was, introduced was the idea of how do we keep a ledger of whatever you want to keep the ledger of among a group of disparate people who don't necessarily trust each other, without having to sort of have a centralized force say that's right and that's wrong. And the broad idea that Satoshi introduced was the idea of consensus, the idea that the ledger is correct if at least half of everybody maintaining the ledger says it's correct. And it's always important to kind of come back to that. Blockchain is sometimes referred to as sort of the ultimate source of truth, and I think can be a little misleading for those who really want to dive into this. It's not necessarily the case that the blockchain record represents truth. It simply represents what the majority believes is the truth, and that is an important distinction. It leads us to understand what many have heard about the quote unquote 51% attack, and of course attacks are in the eyes of the beholder. But basically, the ledger that a blockchain keeps is accurate based on, it's in the Bitcoin case at least, what at least a majority of the users of the ledger system, or the nodes as the term is used, which are the people who operate computers that maintain this network, what they say it is. And in Bitcoin, that manifests itself in a rule that's part of their protocol, which is built on the longest chain. So the blockchain itself is made up of transaction records segregated into groups, which are known as blocks, and validated by the network. And each time a given group of transactions has been validated, that creates a new block, and that then creates the basis for the network forming another block. And so once a block has been created, it's up to each node to determine whether that is a valid block. And if it is, they build and use that block to create the next block, broadly speaking, in the 2-minute version of blockchain. For our purposes and the legal purposes, Bitcoin itself introduces many fascinating issues that are kind of extrinsic, if I will, to the blockchain, or at least not necessarily part of the blockchain. The blockchain itself is very simple in Bitcoin. It simply moves forward the state of a ledger in 10-minute increments in the case of Bitcoin. What gets much more interesting, to my view, from a legal point of view, is the developments that came after Bitcoin. And again, as I think most folks will be aware, that is the most important technology that followed Bitcoin, known as Ethereum. And what Ethereum did differently than Bitcoin is it addressed a point that exponents of Bitcoin would say is very much a feature, not a bug. And that is that Bitcoin, although it can have very simple scripts, which are sort of if-then statements, the Bitcoin protocol does not contemplate any use of more elaborate or complex statements, in particular looping statements. That is, check this, and then if that happens, do it again, and do it again, and do it again. Looping statements is what makes a computer protocol what's known as Turing complete. That is, the computer protocol can do anything an actual computer could do, including creating looped statements. Looped statements have the inherent problem of going on forever. And Bitcoin addresses that by not simply allowing it and not allowing anything complex to occur on their blockchain. Ethereum, on the other hand, asked the question, well, what if we did have a Turing complete contract language? What would that look like? And effectively, that was developed through a version of a common programming language known as JavaScript, and that was mutated into something called Solidity in the case of Ethereum. And Solidity is Turing complete and very cleverly addressed this problem of looping through paying for computer cycles. And so, as many of you may understand, the way Ethereum works is it creates what is effectively known as a virtual computer. That is, each node that it makes up part of the Ethereum blockchain not only validates transaction, but actually executes programs, which is what smart contracts are, across the entire network in a very deterministic way. That is to say, whatever the output is of a given program or smart contract on your computer, it will be the same output, deterministically certain, on everybody else's computer anywhere else in the world at the same time. And that's really the development that has pushed this technology forward so rapidly. Bitcoin by itself is a kind of fascinating technological miracle, and its proponents, again, put it forward as a store of value, but it otherwise doesn't really do anything. It just kind of moves forward and say, you have this, and you have that. And now you have that, and you have this. And which is, again, wonderful in its simplicity. What Ethereum does, because of this ability to run Turing complete programs or smart contracts, is it allows developers to build very complex arrangements. Now, we were always able to build super complex programs before Ethereum. What Ethereum did, though, is it combined a scarce store of value, namely the Ether digital asset, with the ability to run a virtual computer around the world that is deterministically certain. And that really unleashed a huge wave of creativity as people sought to apply these new tools in different and interesting ways. Basically, there's functionally no limit to what can be done, in the same way as there's no limit to the programs that can be run on a computer. But really what makes Ethereum and programs or smart contracts not that interesting is the ability to combine value. So one of the very early examples of a smart contract system that gained notoriety was a group of Germans who developed something which they called the DAO, or the Decentralized Autonomous Organization. And the definite pronoun sort of showed their sort of cheekiness, because a decentralized autonomous organization is simply a set of smart contracts that allow people to interact and create some sort of governance arrangement through that protocol. And what the DAO sought to do is basically create what was functionally a decentralized venture capital fund. So people would buy digital assets created by the DAO, and they would use those tokens to vote, or at least theoretically, vote on investments that would be made by the Ether token, which was used to, oh, that's not a piece of good news. That is the sound of my battery getting low, which I didn't really contemplate on. All right, well, let's see how we do with the battery. We may have to switch to audio at some point. In any event, so so the creators of the DAO created this, functionally this virtual venture capital fund where those interested contributed Ether tokens, locked those in a smart contract, and received back voting tokens to determine how that Ether in the locked smart contract would be deployed. In the category of what could possibly go wrong, similar to the Titanic, before it managed to make it across the Atlantic for the first time, the DAO was suffered an exploit. And we call it an exploit rather than a hack, because really all the exploiter did, whoever that was use the code to their advantage. And it really brings out an important point about blockchain, that the code is what it is. And if someone can figure out how to utilize it in a way that was not anticipated, well, good luck on them. So the exploiter used a recursive loop to drain basically all the Ether out of the smart contract and put it into a separate smart contract that the exploiter controlled. This caused a lot of consternation and resulted in a fork or change to the Ether blockchain that effectively rewound the tape, as it were, to a point prior to when the exploit occurred, and then kind of started the chain off on a fork. If you could imagine a railroad train that kind of started going down the wrong track and then backs itself up, and then, you know, after it gets past the problematic part, forks off in another direction. Amusingly, the forked chain continued to be called Ethereum, even though it was really new, and the traditional chain, or the chain that was actually the real chain, became known as Ethereum Classic. This would have sort of just been there as it was, but a year later, that was in the summer of 2017. The next year, in the summer of 2018, the SEC released a report focusing on the DAO and what happened there, and without trying to assign any liability, notified the market that what had occurred there was probably the sale of securities without any registration. They were made available to retail persons in the United States, among many other jurisdictions, and that this probably violated the law. And if you do it again, you're going to get in big trouble. Generally speaking, nobody paid much mind to the DAO report, or the Section 21A report, as it was known, and merrily went on selling tokens because it was a lot of fun and people were raising a lot of money. And there was a general belief that there was a new sort of paradigm being developed, where known as the FAT protocol thesis, whereby as an investor, rather than owning the software that ran on top of the protocol, if you owned the rights functionally to the protocol itself, then you would be able to capture value in a different and important way. So everybody and their uncle went off selling tokens between 2017, 18, and 19. But in I guess December of 2017, about 6 months after the DAO report. See, so the DAO report is 2016. Sorry, I got my years one off. The DAO launch was 2016. The 21A report was 2017, and in the winter of 17, the SEC went after its first ICO that did not involve sort of obvious fraud, and that was a token sale by a smartphone app called Munchie, in which the company Munchie was seeking to sell tokens that would be used to create an ecosystem around food and restaurants and things like that. And the SEC was successful in stopping the sale and basically said that the token distribution was violation of Section 5 of the Securities Act, and thus per se illegal. But this too did not really stop folks, and that was December 7, 2017, and in the ensuing sort of 9 months or so, a number of very large token sales occurred. Probably two of the most prominent was for a social media app called Kik, and a messaging app, which many of you may know, Telegram. And both of those businesses were struggling to find ways to monetize their technology, and concluded that rather than either selling ads or taking more traditional routes to monetization, as Facebook and others before them had done, they were going to simply sell off the rights to the protocol itself through the sale of a token, and that this would not involve securities because they were just selling a token that allowed people to use a protocol. In both cases, both of those companies, along with quite a number of others, were sued by the SEC. The state regulators also pursued a number of enforcement actions as well. And I think, Professor Guseva, you've done some great work, collating all of the litigation that has occurred around this area and continues to occur. The SEC looked at all these cases through the lens of a very well-known case, which many of your students probably at this point have heard of, and certainly I hope have read, which is the SEC versus W.J. Howey. I think it's W.J. Howey. And that case, going back to 1947, 48, something like that, was a very early case, give or take 10, 12 years after the adoption of the primary securities laws, and interpreted a phrase used in both the Securities Act of 1933 and the Securities Exchange Act of 1934, but was not ever defined anywhere, and that was investment contract. And both statutes, sought to define securities very broadly and included a number of terms, but investment contract was not a defined term. In fact, it had been borrowed from state law and was commonly used in state securities laws prior to the adoption of a federal securities framework, but was not even clearly defined in state law. And given the nature of state law, there was no single definition there. Different states had interpreted their state statutes, somewhat differently. And so it fell to the Supreme Court in the Howey case to figure out what was exactly meant by investment contract. And what the court concluded at the time was the well-known Howey test, which in fact has stood up very well over the ensuing 70 or 80 years, whatever it's been. And that is that an investment contract represents an investment of money in a common enterprise with a reasonable expectation of profit, primarily from the efforts of others. And long before digital assets were created, the SEC and private litigation had enforced many other examples of schemes that followed that pattern. For whatever reason, there are some really interesting fact patterns of various things that were the objects of these investment schemes. So, of course, in the case of Howey, there were orange groves that travelers from the north were invited down to Florida and then went out and pitched, hey, don't you want to buy a little piece of sunshine there? And by the way, you don't have to worry about it because we're going to manage the grove and pick the oranges and sell them, and we'll just send a check to you. And subsequent to that, there are many other similar schemes. Some involved whiskey aging in barrels, other involved various animals being grown to be sold for their pelts. There was an earthworm case, a lot of different cases, but they all broadly followed the same pattern, which was ostensibly commercial sales of something or another, generally speaking, some type of good, some kind of common enterprise or effort to turn those assets into something more valuable in the future, and an expectation of the profit on the part of those who were making the purpose, not a consumptive interest. And the case law that followed, although a bit all over the place, basically, focused on those areas. So when digital assets were sold, the SEC was able to point to the Howey case law, and in particular, one case that the SEC liked was called Gary Plastics. In Gary Plastics, Merrill Lynch had created a product for their wealth management clients in a period of high interest rates, where they collated a set of bank certificates of deposit that in and of themselves were not securities. But what Merrill Lynch did was they selected the CDs and then managed them and gave their customers the opportunity to resell them back to Merrill Lynch in case they didn't want them anymore, which is something that you normally couldn't do with a bank CD. And some of the customers were disgruntled that they weren't told that Merrill Lynch was making some money off this, which frankly is a bit of a mystery. Somebody's thinking Merrill Lynch was not trying to make money off them would be the surprise. But in any event, they were sued for disclosure reasons. And the court agreed in the Gary Plastics case and held that this was indeed an investment scheme. And the SEC has used that case to point out that you can have a investment contract and therefore a violation of the securities laws, even where the underlying asset is not a security. Where things get kind of interesting and where the kick case that I referred to earlier and the Telegram case kind of went forward is the SEC decided that because these digital assets are widely tradable and because their value is frequently linked to the ongoing efforts of whoever is sponsoring it, the kick company or the Telegram company, as the case may be, that the asset itself is a security as well. So not only is the scheme a security, which I think is reasonably self-evident looking at the case law, but they've sort of endeavored to extend the case law further and say the asset is a security. This presented the SEC with a problem, kind of jurisprudentially, because somewhat self-evidently, these assets were different from normal securities, not least of which is they continue to exist even when the sponsor who sold them were to go out of business or go away or no longer be in the picture. And of course, that's not the case for any normal security. If an issuer of equity or an issuer of debt, goes bankrupt and is liquidated, then the equity and the debt no longer exist in any meaningful way. Yet, these tokens continue to exist. And so the director of the Division of Corporation Finance at the time, Bill Hinman, gave a speech, which he called When Gary Met Howie, referring to Gary Plastics, and came up with a kind of innovative theory, which I personally characterize as a little bit of magical thinking, and said that, well, perhaps these digital assets are securities when they're born, but after a period of time, they stop being securities or they morph out of being securities. And as best as I can tell, the SEC has never once cited an actual case for supporting this premise that that is a thing or that is possible jurisprudentially, but they continue to maintain that. So going forward, the SEC has repeatedly asserted that the digital assets are themselves securities. This makes itself particularly relevant as we move forward to the most recent large-scale SEC enforcement action that's currently underway, which is a case against Ripple Labs. Ripple Labs was the sponsor and progenitor of one of the largest tokens out there, which is known as XRP. And in the first line of the complaint against Ripple Labs, the SEC states that they believe that Ripple Labs is guilty of selling something like 14 billion of XRP tokens, which are digital asset securities. So the SEC really kind of puts a marker down saying they believe that these assets themselves are securities, without ever really finding a way to substantiate that. So where are we now, in terms of regulation? One proposal was made by one of the SEC commissioners, Hester Peirce, sometimes known as Crypto Mom, and about a year ago, she proposed a adoption of a safe harbor that would allow companies seeking to create decentralized networks to be exempted from application of all the securities laws, other than the anti-fraud laws, for a 3-year period. And at the end of that period, they would see if they really were decentralized or not. It's a good idea, but it does have some fundamental problems, and it probably represents the worst sides of the compromise, which it isn't really pleasing to anybody. That exists out there. There was also legislation introduced by Congress in September of last year, known as the Securities Clarity Act. And that bill, which was introduced by Representative Tom Emmer of Minnesota, took a different tack and sought to clarify the Securities Act and go in and actually amend the law to address this point. And it introduces a new term, which is investment contract asset, which is an asset sold pursuant to investment contract, and then clarifies the law that an investment contract asset is not itself a security unless independent of being sold pursuant to that contract would otherwise be a security. So if you sell a share of common stock pursuant to an investment contract, it's still a security. But if you sell, a beaver or some whiskey or a digital asset that's not otherwise a security, then just the fact that it was sold in that manner does not make it a security. Obviously, given everything going on in Congress, that was not top of mind for anyone. It may or may not be reintroduced in the current contract. Congress will see. In some respects, and this will be my last little kind of segment before I pause for breath and also see how my battery is doing. But I just want to say a few words about decentralized finance, because in some ways the party moved on from ICOs, which is the term used for these types of sales of tokens or initial coin offerings. And it moved on a bit, and lessons were learned. The lessons that were learned, though, were not so much don't do that. It was more find a better way of hiding the fact that you're doing that. And so in decentralized finance, protocols are created that allow owners of digital assets to interact with each other in a variety of fascinating ways. The simple of which being exchanging digital assets with each other without an intermediary. Others involve creating derivatives, borrowing, and a whole range of otherwise traditional financial kind of arrangements, all without any one single person being responsible, generally done with what we call atomic exchanges, or exchanges that are done, programmatically by a protocol and without any trust needed. So it's you can imagine atomic exchanges. If I've got like I don't know, an ice cream cone, and Professor Guseva's got a $5 bill, and we kind of go, okay, you take it, okay, boom, and so the assets change hands, just like that. So nobody has to have a moment in time in which somebody doesn't have either the ice cream cone or the $5 bill. And that's how these atomic exchanges of assets work, and broadly, DeFi is built on that. Much of that activity probably is not permitted, especially if retail people in the U.S. are accessing it, is not permitted on any number of laws. However, more cleverly, the lesson that was learned was that, sorry, I might sneeze. The lesson that was learned was that rather than kind of hide what the parties are doing, what they did was they say, look, we're not responsible. These computer programs are doing this. Don't you see? It's not us. And so it's almost like a challenge to the regulatory authorities to say, come get us. One way I like to sort of explain a DeFi is imagine a DDoS or distributed denial of service attack on global financial regulation. Just if enough people keep doing stuff, that's a bad sign there. I'm going to go off video when I pause here, and I'll just charge up my battery a bit. But so people are just going ahead and doing this, and I think it will be very difficult for global regulators to stop a lot of this activity. Really, what is constraining DeFi activity at the moment is not any regulation, but simply two facts. Number one, the user experience is difficult. Not only do you have to buy crypto or other digital assets, you have to maintain it in the wallet. Typically, these are self-hosted wallets, so you have to figure out how to manage that. And then you have to interact with all of these protocols, which are not self-evident. And if you make even a little mistake, you just lose all your money. And that can be a little disconcerting. Number two, because virtually all of this activity takes place on the Ethereum blockchain, the Ethereum blockchain, as I said before, allows Turing-complete contracts. And the way they manage that, which I never quite got around to saying, is by charging users a fee for each cycle of compute power that their smart contract uses. And they call that fee a gas fee, GAS, as if like gasoline that you put in your car. And so The cost of gas or the ability to run smart contracts is dependent on the congestion in the network. The more people who want to run smart contracts, the higher people running nodes are able to charge to run those contracts, and the higher the gas price. And at the moment, the gas price is astronomical. And so it's, as a practical matter, retail people cannot run smart contracts, at least without a lot of fancy workarounds, which I can see you've got a lot of clever people in class. Your comments are popping up on my phone too, so I see a lot of clever bunnies out there. So I'll try and be very precise with my wording. But absent, workarounds, the gas fees effectively create an almost accredited investor bubble, because to make the DeFi contracts make sense, you've got to do transactions at a very large scale, and to do transactions at a very large scale, you have to have a lot of capital to work with, that is, effectively. So the two things together, the limitations on the user experience and the high gas fees, I think, are actually work to DeFi's benefit in keeping it out of the eye of regulators for the time being, because retail people just really aren't using it in the regular way, but will remain to be seen. So I'll pause there. Maybe you've been collating some of these questions, and I'm going to also turn off my my screen now so I can charge up my phone.
Thank you very much, Lewis. And we are moving to a Q&A.